Okay, this is section 2 of remedies, and we are going to look at a more modern remedy than injunctions, which have been around for centuries. But there's an awful lot of statutory remedies that exist today that don't arise necessarily as a contract or a tort claim, but that they are created by the legislature. And so you have to be familiar with them, and you need to start to think about them in a little more depth. And this one, the first one we're going to look at is the Americans with Disability Act, which until the early 1990s didn't exist at all, till the first President Bush signed it into law. And some referred to it as civil rights for the disabled, but the fact is it goes well beyond that. And now, I think something I saw when I was looking at this earlier today said that between 2015 and 2016, claims under the Americans with Disability Act jumped by about 50%. So we're talking tens of thousands of claims filed each year. And so we ought to take a look and think a little more of how it works, because it doesn't just affect matters of employment, but especially in the employment area we see it. I've had a couple of claims that dealt with the ADA already. And whether you're going to be a private litigant, it's a lawyer, or you're going to represent companies, especially if you're thinking of representing companies or working in human resources. There's so many state and federal statutes that you have to be aware of that you need to be able to provide your client good advice. And oftentimes what I've seen in my experience with some of these companies is that sometimes they've got someone who is ill-qualified to be making the assessments and and adopting the policies, writing the policies as well, that frankly, at least in one case, that if they had hired a lawyer to be able to do that, which they were paying really good money to an individual who had a junior college degree, that they would have likely saved themselves hundreds of thousands of dollars in the long run. But so there's a lot of money to be made in human resources, there's a lot of money to be made in representing litigants, but you would hope that companies would do the right thing and be smart enough about their policies and respecting their workers. But the Americans with Disability Act is just one of the first ones we see. And so it's not just employment. Also, places of public accommodation have to have to be accessible for people with disabilities. And so we see it in a variety of places where the court now tries to make a determination whether you are discriminating against people with disabilities. And so one of the early cases that actually came about that I thought was interesting, at least to expose us to it, was the Casey Martin situation, where he wanted to be on the professional golfing tour, and what he was looking for was, as he saw it, a reasonable accommodation. He had been Tiger Woods' roommate in college. He certainly could play the game of golf, but because of his deformity in one of his legs, he could not, as he saw it, walk the full golf course that the PGA requires in order to play golf professionally. And so what he said, and this was one of the first suits we saw under the Americans with Disability Act, that he thought that the Professional Golfers Association should make a reasonable accommodation, and that accommodation would be to allow him to use a cart between the holes, so that he didn't have to walk the full length of the golf course because of his leg, which there's no doubt was seriously injured and likely affecting his ability to walk properly, and that potentially he could injure himself to the point where that he could lose that leg. So he sued under the Americans with Disability Act because he said, I have a disability, it affects a major life activity, and you should make a reasonable accommodation for that disability, which under the circumstances means I need a cart to go from the green to the where we're going to drive on the next hole, and then at times use that cart, not obviously to somehow hit the golf ball from, but just to be able to move from location to location. And what he sought is a preliminary injunction. We talked about that last time. He wanted the ability to use that cart. He thought, under the Americans with Disability Act, that since his disability, which would be walking, was interfering with that major life activity, that they should, since he is otherwise qualified, they should make a reasonable accommodation under the circumstances. And the Professional Golfers Association, I imagine like football, I imagine like basketball, I imagine like every other major sport, and some private employers with corporations and the like said, we're not going to change our rules, we're not going to make any accommodation, we make it for you, who knows what we do for the next person. And they said no. So I guess that's the first question that I have for all of you. You read the case. It's been, what, 20 plus years now, really, since then. What do you think he should have got an accommodation such that he could compete on the PGA? Or if we're changing the rules of the competition, does that necessarily mean he's got an advantage, and that's not right if we're playing for the top prize and this or that? Marissa, go ahead.
I think that I agree with the court's reasoning in that it didn't, whether we provided him a card or not, it didn't affect the game or his skill level. It didn't assist him in any way other than to move him from part A to point B, you know what I'm saying? So had it at, like, if we were going to sit there and say we're going to affect the rules of the game, and then that would have an effect on a player's skill level, then that would be different, because then we're changing more than one factor, but we're not changing anything.
So the game is really driving the ball and then putting it in the little cup when you're done. It's not how you get from point A to point B to point C to point D.
Well, I think going from one hole to the next does, like, I think they mentioned something about fatigue. Yeah, it's right. It does, anybody, 18 holes, that's a long day. So going from one place to the next, and I've been on the golf course, they're not close at all. It does create fatigue, but the whole idea here is really leveling the playing field.
Right.
So, he has a disability, so he's already disadvantaged from the start. So just by giving him the cart, I don't think he's any less fatigued than a normal walking person.
And are we altering, though, an essential part of the game? Because that's part of what they argued as well, right? Is that if you do it, that you're changing the rules of engagement here. But they didn't do that in the juniors, right? You could use a cart there. A lot of golfers in some courses require it, that they use a cart. So is this more for TV so that you can see them, wow, now everyone gets quiet, now they walk up the fairway or whatever. So it's more for the pageantry of it? Or is it more, these are our rules and we're not going to change no matter what or who says we have to change? Because right, this is an act passed by Congress. President signs off, says we think this is important, and now you have pushback from the PGA saying, well, maybe important to you, but we don't have to change our rules. Even though I think this is a pretty clear case where he has that disability, so we can just sort of move to the next phase. Should they make a reasonable accommodation for that disability? Is it reasonable, or asking us to change those rules means we're changing the rules, and potentially you are advantaged by it. And frankly, I would imagine then, what if others say, okay, well, if he has the cart, I want a cart too. We all want karts, right? If there is an advantage, as Raymond says, then I'm not walking 18 miles in 90-degree weather either, right? So now you've changed, you've fundamentally changed what we see as our game, and commercially, it may well affect the value of it for TV ratings and TV revenue and all of that. But on the other hand, it's the law, no? So you'd all let him have a card?
I would.
No? Zach?
It's a completely different game when you have a cart and you don't have a cart. Like, I could walk 9 holes and I want to give up, but if I had a cart, I could probably play 36 holes. So it's really is a big part of the game.
Well, and he raises another point too, that they've said at some of the tournaments, they may end up having to do 36 in a day. And if you didn't think 18 created fatigue, try doing two full 18-hole courses in a day. There's no doubt that riding is going to be significantly less fatiguing than being able to, being required to walk. So if it changes it, still make the reasonable accommodation, because otherwise you're saying people with disabilities are just not going to be able to compete. And it's not, we're not saying we're going to, you know, let you use different clubs so that you can hit the ball farther or anything like that, which may be more of a problem. But at the end of the day, you still got to come back to, is this a reasonable accommodation, or as some will see, he's got an advantage now that the rest of us are not going to have access to, and that means he's going to win some tournaments. He's now taking money out of my pocket. Because he's a good golfer by all accounts. He's a good golfer. This could be and you know, especially when we look at professional competitions, the difference between who's number 1 and who's number 10, probably not a significant degree of difference. But someone's going to be coming out on top. But what's your alternative then, though? You're saying, well, we can set the rules, and when we set the rules, that's it. And we don't have to make an accommodation. So I guess we're focusing on, is it reasonable or not? Go ahead.
I think it's reasonable for him to have that accommodation, because if they didn't put that in, that stipulation, then it precludes anyone with disabilities and never playing golf at the same level, at the professional level.
Well, but at the, I mean, and that's what I wonder a little bit about too, and I think it sort of relates to Zach's point. Most people will never play at the professional level. A little bit of an advantage could make all the difference in the world. So maybe we don't all get to be professional golfers, or we're going to read a case doctors or lawyers. But he's got to, you know, if we give him this accommodation, or if the court orders it, then he's got a better chance. But I'm not so sure anyone's arguing either. He isn't otherwise qualified. He seems to have the skill. The disability is real. So I guess we'll focus on what we said. Is this reasonable? And if this one's reasonable, where else do you go? Remember in the Olympics last time, actually I think it was Oscar Pistorius, wasn't it? The guy who ended up killing his girlfriend.
Yeah.
He wanted to use those carbon fiber legs. And they said, wait a minute, that gives you an advantage because they're lighter than legs, they spring and you could be faster. Was that a reasonable accommodation? So now I want to play basketball in the NBA, and those legs allow me to jump a little higher and run a lot faster. Is that a reasonable accommodation?
It's more than a reasonable one.
So it's not reasonable.
Yeah.
So you would tell people, amputees who have lost their legs, you can't play in the NBA because that's not a reasonable accommodation. Would you?
I wouldn't. I just have a moral compass. I think that it's...
You don't? So said. Well, wait a minute though. But you know, those things do look. They actually look pretty springy, and you know, maybe with those legs I could actually dunk a ball. No, but it's going to make a difference, isn't it? Is that an unreasonable accommodation? It makes you lighter, it makes you faster, it makes you be able to jump higher.
Well,
I imagine there'd be people who would make the trade, as sick as it sounds.
I think it goes back to your point, though, that we all aren't going to make it to the league. So even with that accommodation, all these handicapped individuals are still not going to make it to the league. You know, it's just like a whole bunch of people applying to law school. Everybody's still not going to go to law school, no matter how much you want to or desire it. So I still think it's reasonable because it gives a person a chance to potentially get to that point. Now, if they get there, great. If they don't, at least there's that blanket rule that say, hey, you know, you can potentially do this, you know, because of all these, you know, extra, you know, or devices that would help you get there. Because they're disadvantaged from birth, really. That's what the reality is.
But we said with Casey Martin, I thought we talked about, that you weren't fundamentally altering the rules of competition. Are you when it's something like for basketball, those legs, which do allow you to be faster and jump higher? I mean, you know the ones I'm talking, right? They sort of look like springs almost. And that's what they were saying, even running allows you to move, just to sort of propel yourself a lot faster. And so, does that alter the competition? Go ahead.
I guess you could compare it to regular legs, right? And see which is more advantageous. If someone who is a paraplegic with these legs on versus someone who is an athlete, you know, using their regular legs. I mean, if the paraplegic does better than the athlete, then you could say that, you can make an argument that these legs are more advantageous.
Well, just look at, let's take the marathon, right? The marathon, the folks in the wheelchairs finished significantly faster than the fastest marathon runners. So, if speed is all, it's going to be better. Would you let someone in a wheelchair play in the NBA, assuming they were otherwise qualified? Because that would almost seem to pose a hazard to the other 9 players on the court too. But when you asked about, well, does it advantage them? I don't know whether that advantages them on a basketball court because of having to move and pivot and all the rest. But we know from speed standpoint, obviously with the wheels, it's faster than running. But so if let me take Jeeves' point slightly differently. So if it's shown that those carbon fiber legs would generally allow most individuals to jump significantly higher, then that's not a reasonable accommodation?
It's not reasonable.
Not reasonable.
Not reasonable.
So they're out. Out. Because it gives them a competitive advantage that they shouldn't otherwise have. Where Casey Martin is just simply saying, it's not that I'm using a different driver or a different ball. It's not that I won't, on my own, strike the ball and send it wherever I would like it to go. It's that under the circumstances, I just can't do the other part, which a lot of people don't think is an essential part of the game. So that's what you've got to figure out. And it's, obviously, the Casey Martin is just sort of the introduction for us because there's other issues as well with this. But so let me ask that. So when we make an accommodation, or when the court orders an accommodation, are they disadvantaging the others in that environment?
No.
Or are they leveling the playing field, as Raymond said? Go ahead.
I guess you'd have to make a determination based on what accommodation is being made, first of all, and then what that accommodation is doing to affect the field or the sport that's being played, second of all. So, say it's just the accommodation of the driving, right? That's not something that's an essential part of the game. So it's not something that would change golf, per se. But if you have something that's, you know, carbon fiber legs for basketball, that's something that's essential to the part of the game. You can't jump or walk or run or pass the ball without being able to move. And your ability to move is changed by these carbon fiber legs that can give you an advantage. significant advantage over those with legs. So that was materially altering the game. So that's something you'd have to analyze.
So if it materially alters the game, there's no obligation to make an accommodation.
Yeah.
Right? I mean, that's what they're saying is someone who is otherwise qualified to be able to do the job, that you then have to make a reasonable accommodation. So then we're going to have to figure out what's reasonable and what's unreasonable as an accommodation. But that process has to be interactive and has to be worked through as to exactly, A, do you have a disability? And the court has made clear, I think, is that there's a bunch of ways to look at that. But if you're talking about you have a disability, it's that it affects a major life activity. And major life activity means just as that language sounds: walking, running, sleeping, eating, learning, not learning necessarily specific subjects, as we're going to see in McGinnis, but learning generally. And so it's got to really go to the core of our ability to function. It can't just be something that we could improve on. If you have a disability, and you're otherwise qualified to be able to do the tasks, and that's what they've got a whole bunch of things on. And that's, by the way, if you're advising employers and the like, this is really one of these, you've got checklists and you've got dot your I's and cross your T's, because there are certain questions you can ask during the initial interview. There are certain questions you cannot ask. And that's my point about a lot of these HR places and the like. You can't have... A, that staff needs to be well-trained and overseen, and B, you just can't have someone asking those questions without having been well-educated, because simply asking the question then offends and potentially violates the law with respect to that applicant, and B, opens the door to incredible liability, even if the claim isn't well-founded, but the fact is, or the person didn't intend to offend and the like, but asked questions that the state or federal government have said are improper in that process. And the other part of that is then under what circumstances we can have, or we can require of any applicant, medical examinations. Now, not just saying with respect to people with disabilities, but firefighters. There's a lot of occupations where they require a medical examination prior to actually signing you up for employment. And that's generally the way this would work, is that you have to make the job offer and then determine fitness if you require all applicants for that post to have a medical exam. You can't just ask people, obviously, with disabilities, well, we want to have a medical exam and check you out. So there are some very strict requirements as to the hiring process and what you can ask and what you can't ask as well here. And so if you're deemed otherwise qualified and can perform the essential functions of the job, with or without accommodations, and that's the other part of it, is that sometimes you need help with your vision. Sometimes you need some help with hearing, and so they may need some adaptive devices and the like at that location. Nonetheless, with those adaptive devices, you can do the job. You're otherwise qualified. So they look at it either with or without that reasonable accommodation. But then we get into the next phase. This is a relatively inexpensive one for the PGA. But the PGA, and again, this was really early in the process, the PGA wanted to draw a hard line in the sand and say we can do what we want. But the fact is, like every other individual and corporation in the United States, they're subject to federal law like us all. At the end of the day, the PGA was more interested in fighting than trying to figure out if there's a way to resolve it. I think some of this, by the way, was really, most of it was based on TV revenues, TV appearance, and all of that, because the that's what drives the whole professional sports anyway. Go ahead.
I've never seen them walk on TV.
Oh, yeah.
Oh, yeah.
They do?
Yeah, it's
Very
TV.
rarely.
Oh, yeah, they
That's
walk
because
over.
commercials come.
Commercials come, right?
Yeah, well,
So-
that's true.
But
What's the argument they're making?
Oh, no, there are times, like especially towards the end of the tournament, they'll show them, you know, it's,
Or when they hit a big shot under the green, they're walking down the fairway and strapping their glove.
Yeah.
I mean,
But it's like momentary. It's in passing. It's not like you're
well, and
watching
that's
the ball.
why I think the court looked at it and said that's just not an essential part of the game. Why shouldn't they have to follow federal law like everyone else?
But I would argue that when golf was invented, it was before there was golf carts. So I think half of it was sand traps and ponds that you have to navigate your way around, and the other half was it's going to be a 5-mile course. So there's a physical aspect to it.
But I hear that, but is there a physical aspect to it today? I mean, most golfers take a cart, right?
Yeah.
And they still play golf, the whole 18 holes. So the competition really is the hitting the ball, driving the ball, and getting that ball in the cup. It's not necessarily about walking the course. And I think that's where they were in trouble on this, is they wanted to keep it as it historically was. And I do think there's an argument to be made for this is our competition. This is specialized. We like it a certain way. And that's the way we want to present it to the public and the like. The problem with that is, well, why couldn't any other employers make the same argument? I don't want someone with a hearing aid being my receptionist at the front door. I don't want someone who needs a wheelchair to do this or that. You know, we want to project a certain image. Well, if you sort of carve that out for the PGA, how is that not eligible for every other employer who doesn't want to make the accommodation for people with disabilities? And that's where I think the court was worried, is that if we carve out this, are we going to carve out this exception here and then have others make similar arguments down the road? And the fact is that that would be very troubling, is that because, again, if you look at why the act was passed and what it was called initially, it really was seen as a civil rights for the disabled. And I'll tell you, having done some of these cases, is when push comes to shove, the first person out the door during hard times is that person who oftentimes, by the way, is one of the best employees in the place, because they appreciate the job far more than most of us actually oftentimes do. I had one over here in Middlesex County. Couldn't have been a nicer guy, and there's no doubt in my mind, and there's no doubt from what I saw of the evidence that it was simply based on his disability, and made no sense because his evaluations were terrific, but at some point they were done. And they didn't really even have to make much of an accommodation. It was just almost to a much greater extent, a straight discrimination claim. So it's not unfortunately uncommon. I had another one that was really big, and the simple accommodation was I can't tell. There were just two small accommodations that they were required to make, which would have been absolutely no skin off their back. One of which was just simply to be able to use the closer bathroom. And I can't tell. The other one there's non-disclosure agreements and the like, so I can't go into details about the other, because the other one would be too identifying. But the other one wasn't. The other one was something we would all want done, period, as customers and people who would be in one of the big box retailers, and they just fought, and there was no good reason for it. But because we want to do things the way we've always done things, and unfortunately, frequently that is the way a lot of these things lay out. And the most important thing, I think, to at least take away, Casey Martin, obviously the PGA has plenty of money, and he obviously had some funds. He went to Stanford. He had an ability to do well in these golf tournaments, so it wasn't that either side didn't have the money to spend on lawyers, but these things become enormously expensive. And that's the other part of it, just as we move to the next case. Under the Americans with Disability Act, not only am I entitled to collect the damages, but I'm entitled to collect, if I'm successful, attorney's fees as well. And obviously, if depending on how far down the road they litigate it, and especially if it goes to trial and you're successful in obtaining a judgment, you're talking hundreds of thousands of dollars. And during one of my cases, case I had, the lawyers up in Maine had a similar case, and so we would talk, and their problem, they had it against the same defendant, different store, but same defendant, and it was discrimination, failure to make an accommodation, it was pregnancy, and ultimately she was able to go back to work, then quit and went somewhere else. But the bottom line is, damages, her personal damages are relatively modest. I don't know, maybe $7,500, $1,000. But in talking to them at that point in time, while her damages are relatively modest, her attorney's fees at that point were about $350,000. And so the problem is, 75 grand's not going to do this. Even if it might have done it at the outset because you hadn't incurred all these attorney's fees. But now at this point, they were likely going to lose this case. They had doubled down on bad decision after doubling down on bad decisions throughout. And now there's no way to really settle it. They're going to go to trial. The defendant's going to lose, and now the defendant's going to pay, in addition to her damages, which are relatively modest, they're going to probably pay $400,000 to $500,000 in attorney's fees. Why? Because the Act requires that the losing party will pay attorney's fees. The defendant, if the plaintiff is successful, the plaintiff will be awarded the attorney's fees from the defendant. And so now, when you're providing that advice to the client, you better make sure that they understand that there is a bigger risk if you go all the way to trial and lose this, because lawyers these days, doesn't take much money at all if you're going to try a case to get to the $200,000 to $300,000 range. The numbers are just ridiculous now. 1,000 hours times $300 an hour is $300,000. And a lot of cases, especially with these, and especially the way the law firms act when they represent these corporate defendants, 1,000 hours is almost a foregone conclusion, because they're going to fight through discovery, they're going to fight at summary judgment, they're going to fight a motion to dismiss. 1,000, and you're going to prepare your case properly for trial. It doesn't take a lot to get to 1,000 hours at all. You know, even if you keep it at 500 hours, that's still $150,000 at a relatively reasonable hourly rate. So you've got to be cognizant of providing them good advice throughout. And that's the last piece before we move to the next piece. Sometimes people bring these suits, especially in the public accommodation places, the restaurants, the stores and the like, for not having accessible physical accommodations. They bring it as sort of a strike suit to make money. That because the plaintiff gets damages, lawyer gets attorney's fees, and defendant gets to foot it all, depending on how far down the line they want to go. But there's a lot, you know, just one last thing, so I'll tell you. So I broke my leg in July. So I had to go to my dentist office, I don't know, August or September, whatever it was. I had the crutches, and I had the leg in a cast. And I get to my doctor's office. There's two sets of stairs. One cement with not much of a railing. I'm thinking, And it must have been the first month, so it must have been August, because I was pretty unsteady still then. I'm thinking, and by the way, it's not just my doctor's office, it's a 2-story office with multiple doctors in this building, and attorneys in this building as well. And so both of them must have tons of people with disabilities having to get access to these premises. And so I came in the back way because I figured, oh, there must be an elevator, and it's a doctor's building. There's no elevator, so now I had to go up another set of stairs. So I get up to him, and he's a good guy. And I said, there's no elevator in this building? He said, nope. He said, it's a condo building, and the owners voted a few years back when we had plans to do it, that the majority said they didn't want to do it. I said, I don't know. I mean, you know, I think you got some issues. I think you got some liability issues here. At least they should have one of those chairs, you know? I mean, that's not that expensive. And he said, well, I wanted to get it done. I said, well, I'm not sure that matters that you voted yes, because it's the building as a whole that's going to be sued. And it struck me as incredibly, because here's the other thing. It's not just a disability issue. I'm at the top of those stairs, unsteady. If I go back down and mess up this leg again, now you've got a personal injury suit as well, because you simply chose to not comply with the law at this point, and it's a doctor's building. And I'm thinking, you know, how many other situations are like that out there that we don't realize because we don't need the accommodation until you need it. And in talking to my doctor, who's a really good guy, and he understood it right away, and the issues right away, but I'm thinking, you know, these are educated people now. These are doctors and lawyers who own these condos in the building, and they know more than anyone what the issues are for people with disabilities because they're using their facilities all the time, and they nonetheless expose themselves to that type of liability. Even if they don't want to make the accommodation, to not recognize that the civil suits that potentially follow are far more expensive than figuring out a way to make this work. And that is the thing that in a lot of these situations, a lot of companies, once they face with the suit, they have to try and fix it quickly because those attorney's fees are going to be likely more crippling than whatever accommodations and modifications you have to make to the physical structure. There's a lawyer around here who that's 50+% of his practice. He's got a client who goes around looking for problems, and they file suit to fix them. Now, I'm not just saying it's about money, because I'm thinking in part it's about righting wrong and making things better. But both the plaintiff and the lawyer are making a lot of money in that process.
Isn't that fraud?
Well, what's fraud? If I want, like for instance, I want to go into the building, I can't. That's what this act was supposed to do, right? It was supposed to level the playing field. So if you haven't done it, why shouldn't I correct it? Why is it any different than people saying I won't sit in the back of the bus, or I won't do this, or I won't do that anymore, right? This, for people with disabilities, it's of a similar ilk. And you know, we have this in the spring every year, the organization down the street, which does a lot for people with disabilities. They have their annual meeting here, and you hear stories that it's not just stories. I mean, it's real that the access issues and the employment issues and all are significant. But let's talk. Let's go to, I think McGinnis is next, isn't he? Because I want to ask you about that, because I think Casey Martin was pretty clear, but is McGinnis next? First of all, I think he is, isn't he? Yeah. Okay. So is McGinnis? Is he a malingerer? Is he just making it up? I mean, is he trying to push the boundaries here? He wants the medical school to give him a satisfactory grade because he has a disability. And so it says, during his basic biochemistry course in medical school, Mr. McGinnis informed the professor of his anxiety, but indicated that he needed no test-taking accommodations. He requested only that the professor set clear grading standards for the course and not regard him as lazy. And it says, according to the medical school's grading policy, oh, so he received a grade of marginal, and according to, in the basic biochemistry course. How would you all do in biochemistry? You think you could get to the level of marginal or what? And so then it says, and the students who receive the grades, marginal grades in more than 15% of their first year courses must repeat the first year or leave the program. When he earned another marginal grade in cardiovascular pulmonary physiology, more than 15% of his grades were marginal. He was offered but refused the opportunity to take makeup exams in biochemistry. After 3 makeup tests in cardiovascular pulmonary block, he still didn't get a satisfactory grade. He chose not to repeat the first year curriculum. Instead, he filed suit against the university because they wouldn't accommodate his disability, which is the anxiety he has with some of these subjects. So they go through, and they say, parties agree that Mr. McGinnis has an anxiety disorder that manifests itself when he takes chemistry and mathematic tests. Me too. No? Chemistry and math, I mean, they're tough subjects. Do you ever have anxious moments like what? Con law? You all take con law? You all taking con law already?
I have anxiety in every final year.
Well, and you do, and again, especially especially if you think about some of these subjects, biochemistry, chemistry, and math I always did well, but I always had anxiety, especially as it got to higher levels. I mean, isn't some of that to be expected, right? In your harder courses, my guess is you had more anxiety.
I don't even know how to level out my anxiety. It's just anxiety.
Huh?
For me, it's just anxiety.
In every course?
In every course. I mean, for me, it's a little bit, the anxiety comes from the financial burden of coming to law school.
I hear you.
You know, so that's where my anxiety is like, oh crap, like if I don't pass this, then my whole dreams is pretty much gone. You know, so that's for me, that's where
Why don't you carry a little more weight on your right? No wonder you get a little anxious during those tests.
So, I mean, there is that level of anxiety, I mean, in any type, especially in medical school. I mean, medical school, law school, I mean, any high level of education, there's always going to be some type of anxiety.
But let me ask you then, so is Raymond's anxiety likely more one that would have to be accommodated under the Act than, because with his anxiety disorder, it says the district court correctly held that such a disorder limited to certain academic subjects does not constitute a disability under the ADA, right? Like if I have an anxiety disorder with biochemistry and anatomy, but the rest of them, those other ones that I think are easier and not so bad. I mean, is that his problem? Is that he's saying, well, you know, in a couple of these, I'm in trouble. What? In a couple of these, we'll all be in trouble, no?
I think it's selective anxiety here. He's trying to pick and choose the courses that he's anxious about. It's not necessarily like, in Ray's case, it's blanket anxiety, where it's like pure anxiety over all fronts. In this case...
So his would be likely more recognizable under the Act than McGinnis's.
Correct, because it's not selective, right? It's
Well,
not.
and I'm not sure he's selecting it. I think in part, but I hear your argument. I think is correct, but I just wouldn't call it selective because he's saying, you know, listen, God, you must have been more anxious in con law than most of your other exams. No, you haven't taken con law. Yes, you have.
Yeah.
Okay, so you've all had con law.
Can't confirm.
Huh?
Can't confirm.
No, really, right? I mean, I would think so. I've seen people in the past come out of those exams crying. You know, yeah. Yes. People are great. No, it's not funny.
I was crying until I got my grade in the mail.
I saw a lot of people.
After the
No, really, right? I mean, so there are some that are gonna be, you're gonna be more anxious for. But in order to be able to show you have a disability, you have to show that it affects a major life activity. Does this affect a major life activity? Or is he saying, in certain areas, it affects my ability to learn? Because that almost is his flaw here, right? Is that in certain areas I can't learn. No. What they're saying, no, you've got to say you can't learn. And almost if you think about it, it's kind of interesting because they make the point as well. Well, if you've gotten to law school or med school, you've learned all your life because otherwise you wouldn't have gotten there. And so his anxiety disorder, I think he said somewhere here in the past, he has compensated for by studying more and doing something else. I forget what he said. But so by his own testimony, he's got a problem here because A, he has been able to learn up to now, and B, he's compensated for that. If it's a disability at all that affects a major life activity, he's been able to successfully compensate it in the past by doing certain things. And so I just want you to look at the way the statute sets this out here, because I think they do a nice job on page 79. No qualified individual, and this is the act has been changed somewhat. 2010 we had some new amendments, but this is a good case to think about it. No qualified individual with a disability shall, by reason of such disability, be excluded from participation or be denied the benefits of the services, programs, activities, and this is the public entity, otherwise they're subject to discrimination claims. A qualified individual is someone with a disability who, with or without reasonable modifications, meets the essential eligibility requirements to receive those services. A physical and mental impairment that substantially limits one or more of the major life activities of the individual. And so when they then go on to explain it further, it says the regulations illustrate the meaning of major life activities: caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. Well, what we're talking about is not a relatively minor impairment. It's got to affect a major life activity in order to qualify under the Act. And his problem is going to be as the court ultimately starts to think about learning. And to me, it's actually kind of a problem if you think about any graduate programs and the like. You learned, or you wouldn't have gotten here. Very few people get to medical school. A few more, I guess, get to law school, but that means you've learned throughout. Now, the Act has changed to add in this other area that I want to mention. It's to get into this, do you have a disability? It's added language that or has been treated, it has been viewed in the past as having a disability, right? So that if you've got accommodations in the past, if there's a track record of that, that's important to recognize, because if you think about this sort of exception, well, if your educational institutions have accommodated you in the past, well, then you can learn with accommodation. So it does affect a major life activity. And the other thing is the other part of the language the court has the Congress has added. Either you have a disability, or your employer acts or treats you like you have a disability. So then, there's sort of the perceived disability could have a claim for discrimination in the workplace as well. So he says that his academic and functioning, that's what it affects, not his ability to work. And the question is, does he have the substantial limitation such that he has, in fact, been discriminated against because of their failure to accommodate it? But let me ask you that, because that's the other thing. What's the accommodation here that he seeks? So, okay, let's assume he's got it. It affects a major life activity. Are you going to tell a doctor that they shouldn't know anatomy, or they don't have to know anatomy? I mean, I hope it's going to be your doctor, not my doctor, if you're going to do that. No, really, right? I mean, and same thing for lawyers. You're going to say, well, you don't have to take con law then, because it would seem pretty essential if you're going to be in this business to have some better familiarity with it. And that's the other part you need to start to think about. If we're going to give you an accommodation, are we, in essence, just like with Casey Mountain, are we going to alter the rules of competition then? Are we going to take away a skill that's fundamental to that profession? And to me, you know, biochemistry, I don't know much about it, but it would seem to be right in the same vein as that sounds like a pretty important one I'd want any doctor to have passing knowledge of. And he doesn't by the law school standards. And if we take that out, and are we then saying that his deficient knowledge in that area is okay as a member of that profession, right? You know, I've actually had people say, well, I can't meet time standards. That's my disability, is can't submit things on time, can't get them done on time. I don't think then you're qualified to be a lawyer, because the court's not going to give you an extension every time for filing, and you've got to figure out how to accommodate it like McGinnis should, right? Extra study habits, start earlier, do something, because if you can't meet that requirement in our business, because the courts are not going to accommodate that all the time, then you've got a problem being essentially qualified for the position. And I sort of see a little bit, I see that here with McGinnis, is that he's actually asking to be excused when from some pretty fundamental, and I think that's the way the medical school saw it, fundamental foundations, fundamental requirements to be able to be a good or even functioning doctor. Plus, what would be the next steps? So then you get excused from the bar exam or the medical school boards, right? I mean, that's the other part of the problem here now is, well, okay, so then, because they're required to make accommodations as well, but what would those, how far would they have to go, right? Would they be able to say, well, you're not going to take that part E of the med boards because you have a problem with biochemistry or anatomy? That's not, is that a reasonable accommodation? You want your doctor to be missing important parts of it. You want your lawyer to be missing important parts of it. Because the bar examiners will make accommodations, the med boards will as well, but usually it's items like time, quieter space, you know, maybe even go further, but I'll be honest with you, the bar examiners fight it all the time. And there's no, I mean, they just do. And there's no good reason. I mean, like, you're the bar exam, why shouldn't you follow the law? But they're going to make you jump through hoops to do it. And the sad thing is, they know how time-sensitive the test is, so that if, so they know, especially people with disabilities are under even more stress and anxiety because of the time. You know, to me, I just don't understand why they just don't give everyone more time. If that's what you're worried about, it sort of tilting the field, and again, I don't see it, but that's what, you know, that's what they're worried about, then make it a 6-day test. And don't make it time sensitive for anyone if that's, but that means we got to get the convention center for a couple extra days. Well, so what? No, really, right? No, I mean, seriously, to me, so what? Because we shouldn't be rewarding speed. We should be rewarding knowledge and wisdom. And so especially, it shouldn't come at the expense of people with disabilities. And they understand. I made this argument directly. The fact is that, you know, no one wants to change what they're doing, even though we've got laws that say, well, you have to. And so they make people jump through hoops. But at the end of the day, I want my lawyers and my doctors to be qualified, but let's figure out a way that we can qualify them. McGinnis, he's out? Out.
It's an accommodation, not a free pass. They let him take the test over again, which I don't even think is necessarily right, but
I agree
say
with-
it is, you can take it a couple times and pass it, you can't not take it at all and just move on.
Well, and then they also, I mean, to me, they went above and beyond, because then they said, okay, you still didn't pass, you can do the whole first year over. I mean, he had a lot of opportunities, and by his own admission.
He said no to it.
Huh?
Didn't he originally say no accommodations?
Yeah, right. They asked him, "Dude, what do you need?" And he said, "No, he's going to work around it." But when the results were unsatisfactory, he then said he needed. He said he wanted to be excused from the course completely. I don't think any school has. If any school has to waive essential requirements that they see deal with the competency to enter that profession. If there's, marginal courses, or we ask you to do something that really. You're supposed to go on the weekend retreat to volleyball or whatever. Well, that's not essential part of being a lawyer. My son's middle school, they go for a weekend. It's supposed to be a bonding experience to nature's classroom. If some kid with a disability can't, or some kid whatever doesn't want to go because they need an accommodation, it's not an essential part of completing middle school to be able to have to do some things like that. But I think the courses that we're looking at here, it's hard to say that the medical school is wrong in saying that those are pretty important courses that we would want our doctors aware of.
I think Mr. McGinnis screwed himself too. I mean, he claims anxiety, chemistry gives him anxiety, but yet he's a forensic chemist.
I hear you, right?
I think a little bit of his anxiety probably comes from the fact that he's holding two professions while he's going to medical school.
Yeah, I agree with you. And I think also, though, these courses would give anyone, like you guys have all said, law school courses give you anxiety. Geez, these, I can't imagine what it would be like having to study this and go back at the early science stuff. But, so... what he wanted, as the court saw it at the end of the day, was an unreasonable accommodation. And educational institutions, as it said here, are usually accorded some deference with respect to educational decisions. If he wants to, I actually did agree with Zach. I thought they made pretty generous provisions to say, well, you retake it again, take it again, and then you still didn't make it, okay, redo the whole first year. Not that time isn't a problem, but again, we're talking about, as I would see it, important education that he should have and competency that he should have if he's going to, at the end of the day, treat patients and the like. So here they're saying he's asking for an unreasonable accommodation under the circumstances, and he is out.
That's like me coming to you and say, I get anxiety from federal civil procedure, knowing well that majority of the cases out here deal with civil procedure.
Well, and it's I had one time. You guys, how many of you in property right now? Oh, great. I had someone say and I didn't know such a thing existed. There's how some of you hate math.
Yeah.
There's actually they put a name to it. There is some math-phobic disability. No, seriously, you can look it up. And they said, I can't do property because of the rule of perpetuities. I can't, which is like what this little speck on. No, I can't do it. And here's my doctor's note that I have to be excused from property. But property is a pretty essential course in law school too. But you can look it up. But there is some type of math-phobic disability that you really, and I had a letter, but again, like McGinnis, struggle through, study harder, and I don't see math as being that, but I'd never heard of it before, and I said, really? And I started doing a little investigation because I got a letter that some doctor put their name on it, and it's true. So you can find, I thought the time one, the first time I heard that, I said, well, you got to comply with time deadlines. There's only so much you know, in our business especially, because that gets you into malpractice, that's going to get you sanctioned by the court, it's going to have your clients all over you. And listen, on our best day, I work with people in this building who have trouble meeting time deadlines. You know, wait till the last minute. You all procrastinators because you shouldn't be. Because in this profession, to wait till the last minute, you are going to have so many sleepless nights. But there's good lawyers in this building who like to live on the edge and do that. I don't get that. But yeah, you got to meet time deadlines in our business, one way or the other, because the courts are not accommodating in that. We've got a case in Connecticut we just finished. My God, if you don't do it, like they are deciding things that, like, right now, because the papers are due at 4:30, and whether the electronic filing is jammed or whatever. Honest to God, I've never had a court act like that. So if you don't meet the deadline, don't even bother with excuses, at least in Connecticut, because things are decided virtually immediately upon your seconds late. We're not late. I'm saying from the other side, they've missed a couple things, and it's good for us, but they're done. So you owe your client at least that. Let's talk about Toyota Manufacturing versus Ella Williams, because this is another worker case, and they're all worker cases where the worker is sometimes sometimes the worker is pushing the boundaries, and other times the employer is trying to run a tight shop. And that's, I think especially in Toyota, that's in part what's going on here, because, and I could ask you about summary judgment, which you all should know, but since Raymond said you're worried about Civ Pro, I'm going to give you a pass tonight. But I can't tell you enough, and we'll obviously look at it before the semester's over. But in civil cases, and if you guys are going to do civil litigation, you've got to really have a good handle and understand summary judgment and understand the whole process. And we'll look a little more at that. But every civil case, you're fighting about summary judgment. Both whether you're plaintiff or defendant, you're fighting about it. And oftentimes, until that whole issue is resolved, you don't know you're going to trial. And again, I told you this first year, but as a practical matter, some judges simply favor summary judgment, even if the Constitution should say otherwise, because it's a lot easier for them. Once I decide summary judgment, that case is gone. I've disposed of the case, and you can go take it up on appeal for the next 18 months, and best of luck. So it's a lot less work than sitting there setting aside a couple of weeks for a trial. Even just, you know, the simple process of impaneling a jury is going to take you 3 days or so. So frees up a lot of the time for the court. And so as a practical matter, you know, some judges just simply like granting it, even when they're intruding into what should be the jury's province, if there are facts in dispute. But at any rate, so we have Ella Williams, who did in fact have some I'd say significant medical issues. She sought treatment at their in-house medical service. She's diagnosed with bilateral carpal tunnel syndrome, bilateral tendinitis. She had work restrictions with respect to lifting and carrying weight, as well as engaging in constant repetitive motion. Toyota, and so at some point she comes back to work. And then Toyota said, we want people to rotate through the 4 positions on the line, because no one wants to stand there with their 2 arms up over their head all day doing that work. Well, really, I don't know, if I asked you all to put your hands up right now and hold them up for as long as you could, with nothing in those hands, there would be relatively soon our hands wouldn't be up there anymore. Imagine if you had to move equipment and that was your job 8 hours a day, and just even if I'm just putting in screws or whatever, no one wants to do that job for 8 hours a day, and they're not going to do it forever. They're going to quit. And so Toyota decided it was in their interest to rotate the employees through all 4 of these jobs, so that everyone could share the most horrible job that Ella said she didn't want to do anymore. And not just said she didn't want to do, said her doctor says that's really impossible for me to do with my condition. Which, you know, I think is legitimate. I mean, if you look at their own medical people said that these were her problems, that she did have significant issues like this, and she wanted to work. So she says she's disabled. She can't do that job, but she wants to work. She wants to earn. And that she says that she's disabled under the ADA because her physical impairments substantially limit her in manual tasks, housework, gardening. Well, no, she's not saying this. This is what the physical impairments may be. She can't play with her children. She can't lift, and she can't work as she would like. And these are major life activities. And as you can see in the case, and it's kind of an interesting process they go through, is the question, is she otherwise qualified? And is she, does she have a substantial limitation to perform those manual tasks? And as you go through it, can she work? The answer is yes. She can't do all of the work that Toyota would like her to do. And so, does that mean she doesn't qualify at all for a reasonable accommodation? Because, frankly, telling her that she could do 3 of the 4 jobs, that's not, as she would see it, not an unreasonable accommodation. But my belief is that Toyota doesn't want to have that policy set in place, because then no one's going to want to do the crappiest job of the 4. And how am I going to run my floor if everyone's begging out of the toughest job? And so it's kind of unfair to the individual who I think definitely has a disability, but does the disability fall within the Act's parameters, right? You have to have a major disability which affects a major life activity. She can work, she just can't perform this work for long periods of time. You would think, as a policy matter, we would still want people to be able to work, even if that job is more limited. The question is, though, does Toyota have to accommodate her? And at the end of the day, the court says they don't have to accommodate her under the circumstances. She can work. The fact that she can't do this work that Toyota wants her to do likely means that she's got to find a different job somewhere else. That Toyota is within its rights to be able to say, no, you have a choice, this is the job we have open. And the fact that you can work, we all agree you can work, you just can't do portions of this job that are necessary in order to do the work we have. So it's kind of, to me, it's a kind of a disappointing result, certainly for her, because she wants to work. She just can't do all the tasks that they would like her to do. Well, the fact is that you have to be otherwise qualified to perform the job with or without the accommodation. Asking that the accommodation be that you don't have to do 25% of the job likely means you're not otherwise qualified. So she's out. Even though she's got a disability, it's not the type of disability that affects a major life activity to the full extent that the Act requires. And so she's out. Let's take one last case you've got before you today is EEOC versus Waffle House. I want to mention EEOC quickly. A lot of these ADA cases, a lot of discrimination cases, you have to start by filing a claim with the agency. The agency can be Equal Employment Opportunity Commission, can be Mass Commission Against Discrimination in Massachusetts, but there is a requirement that you exhaust your administrative remedies by filing a claim with the agency before you can just run to court and file the complaint. For instance, in Massachusetts, once you file that complaint with the MCAD, you can dismiss it, and it would be a good idea to dismiss it virtually right away and then proceed to court, but you have to file it there. It's just a crazy thing. The reason you would want it dismissed and not wait is they will take forever to do anything with the claim. So you could be there 3 or 4 years waiting for that to grind its way through. And that's that. Plaintiff, I was going to say, I will say wants, but I'm going to modify that. Plaintiff wants to get to court as quickly as possible. The reason to get to trial as quickly as possible, the reason they want it is that's what you want, because that's when you get cases adjudicated, or that's when cases settle. I can talk to you all I want about, you know, ADR and the rest of it, but people settle the closer they are to actually seeing the trial and the potential execution. So you can't waste 3 or 4 years of someone's time up at the MCAD. Last case I had up at the MCAD, we went to mediation, already had a finding that they had likely discriminated against, and they were trying to, the MCAD was trying to use as an argument, you ought to take, which was their ridiculous offer, you ought to take their offer because this was, you won't get out of here. You won't get a trial from here and then have the commissioner uphold the decision till at least 3 years from now. And the case had already been there 1.5 years. 4.5 years. And so their argument to me was take a ridiculous settlement offer because that's the best it's going to get because we're slow. And this is an agency that's supposed to be there to help people. Another important thing. So you have to exhaust your administrative remedies and file, but then you can dismiss it and file. EEOC, by the way, is not as slow. EEOC is very helpful. Oftentimes will give you good reports, good support to be able to move forward with, and a fair investigation. Now I haven't had an EEOC claim in probably about 3 or 4 years. But, so I don't know what their backlog may now be with respect to the new administration and all the rest of it. I wouldn't be surprised if it's slower. But generally, historically, they do good work and they do relatively quick work. One last piece on this. You think of statute of limitations in years, right? 2 years for a claim against a government agency. 3 years for torts and mass, 4 years 93A, 6 years for contracts. So you think in years. Discrimination claims, days. 300 days. Okay, so that's not even a year. And the other thing about 300 days is that it's got to be filed within 300 days, but then your damages are for the 300 days preceding it, right? That's your period. So don't think I should even wait 300 days, because I had defendants argue that all of his damages occurred, you know, for instance, 3 years ago. That's when the initial serious breach happened. And then they doubled down on it for the next 2 years. But their arguments were that he was hospitalized 2.5 years ago, seriously hospitalized because of this, and that wasn't compensable because he's outside the statute of limitations. My argument was it's a continuing violation, and all of these damages flow from all of them. But it's not a bad argument. It wasn't a bad argument. It had me concerned that so even when you think about waiting 300 days, the sooner you file, the better. And especially, you just be cognizant of that it's not the time period you think. The last thing, I just want to make the point about EEOC versus Waffle House, which was Darius's favorite place to eat in the South, which I was not impressed with.
It's not.
It's not. It's not. It's just great. Really. He said, oh, wait till you get there. Wait, you're going to love it. I said, seriously, you built this up? At any rate, the fact that an individual, and a lot of individuals now within their employment agreements, a lot have arbitration provisions and waiver of the right to go to court on certain claims. The fact that the individual signs that doesn't mean you've waived EEOC's rights to investigate and pursue remedies for those problems. So you still have a friend there, but those clauses and those provisions, those required or agreed arbitration provisions, are creating problems for a lot of employees. So that's the first place you start with any of these actions, is take a look and see what, if any employment contracts
there are and what those provisions may be. A lot of them are also going to have choice of forum clauses well in these days and choice of law. So it's the first place we start on this. And by the way, even if it had such clauses, I researched a lot to make sure that those clauses in that jurisdiction are enforceable, because sometimes you might be able to escape it as well from that standpoint. I will see you next Tuesday. Stay warm.